Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman. While court is in session, there will be no talking, no sleeping, chewing up gum, or reading any materials, definitely no driving. Thank you. Court is now in session.
Thank you. This is case number 14-11-4478. This is Michigan Schools and Government Credit Union versus Randall Winkerman. The matter is before the court on the issuance of a subpoena. There was a judgment that was previously entered in this matter, and that judgment was entered on the 26th of January 2015 for $22,001.66. All right, for Michigan Schools and Government Credit Union, your appearance at this time, please. I have someone from Michigan Schools and Government Credit Union. Do I have Mr. Winkelman on this Zoom? Randall Winkelman. All right. It appears now that where this was set on for 9:30, the defendant has not appeared, nor has the plaintiff appeared on the subpoena in this matter. Accordingly, the subpoena will be dismissed. So ordered at this time. The court now calls case number 22-19-2936. This is Farm Bureau Insurance of Michigan versus Corey Tone. The matter is before the court, set on for a review hearing in this matter. Your appearance for the plaintiff, please.
Good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Thank you, Mr. Cox. Good morning to you, sir.
Good morning.
I'm looking for Mr. Itoni, I believe it is. If you want to assume, sir.
I'm here, Your Honor.
All right, thank you, Mr. Itoni. I see you there. Good morning to you, sir. All right, and also update me now, if you will, regarding this matter, Mr. Cox.
Yeah, Judge, when we were last before the court, I think Your Honor made it clear that you very much wanted us to reach settlement or at least engage in settlement negotiations last month before the holidays. I think we were also instructed to go ahead and send to the defendant copies of the damages in this case because they seem to be in dispute. And it looks like on December 6th, we did mail to the defendant copies of most of the claim file as it pertained to damages. It looks like in the interim, we also left a couple voicemail messages for the defendant, and we just haven't been in contact with him. I guess maybe what the winning move might be is to put us in a breakout room for a few moments just to see if anything has changed relative to his attitude towards settlement.
Yeah, that seems to be a good starting place, Mr. Itoni. I'm going to put you in a breakout room just so the two of you can talk and see whether or not there is some room to get to the conclusion on this matter. And then you'll come back in the courtroom once you've had that opportunity. So I'm sending you a notification, and counsel, I'm sending you one as well. And I will stand by until until the two of you return.
Thank you, Judge.
So the court now calls case number 22-243382. This is first name is Old, last name is Chewuke versus 6th Precinct Department. The matter is before the court, set on for a motion for summary disposition hearing regarding this matter. Your appearance for, do I have Mr. Chewuke, if I'm pronouncing correctly, sir? Say your complete name. Say your complete name. What's your first name?
Onyemachi Chukwueke.
All right, thank you, Mr. Chukwueke. And I'm trying to pronounce it correctly. And good morning to you, sir. For the 6th Precinct, your appearance at this time. All right, this is a City of Detroit matter. They filed a motion for summary disposition in regard to this matter. Let me find out where the city is on this, because I don't see Mr. Michael's in the Zoom at this time.
Your Honor, I've already filed a default on on the city on the 19th because they didn't respond to the court.
Yeah, well, they filed a motion for summary disposition, sir. They filed that in December.
They did that after I came downtown to file for default.
Well, their motion was filed on the 9th of December. Your application for default is dated the 19th of December.
Well, the motion on the 9th, I didn't receive. I received the paperwork I received from them saying that it was granted. The date was issued was December the 20th.
Yeah, well, I'm telling you now, I have paperwork filed in the court's file. That paperwork is dated December the 9th.
Gotcha.
Your paperwork is submitted December the 19th. So the city is not in default. All right, so let me find out where the city is so that we can have a hearing on that motion, sir. All right, so just stand down. I'll come back to you. Let's see. Do I have Hearst versus Midtown? I'll recall that. Let me deal with 18-241-991. This is Owenu Jones versus Raina Al-Hadi. The matter is before the court, set on for a review hearing on today's date. Your appearance for plaintiff in this matter?
Your Honor, this is Michael Elkins for defendants. I've just spoken to Mr. Palmieri. He's getting on right even as we speak.
All right, very well. So as soon as he gets here, we'll call this matter back and address it.
Thank you, Your Honor.
Thank you.
228, that's an in-person. She's on the home.
Yeah, that's well. Now you know who not to tell too.
991, Owanu Jones versus Rana Al-Hadi. Counsel for plaintiff, your appearance at this time.
David Palmieri for the plaintiff, Your Honor. I am so sorry I was late to court.
Not a problem, sir. Your P number for the record, counsel.
Yes, sir. P26796.
All right, thank you, counsel. Good morning to you. And Mr. Elkins, your appearance at this time, sir.
Good morning, Your Honor. Michael Elkins appearing on behalf of the defendants, P29725.
All right, thank you, counsel. And again, good morning to the two of you, and welcome back on my enduring matter here. Case that actually began in the small claims division of the court. Why don't somebody update me? I know you've been making some efforts. Let's see if we made any progress.
The court may recall that when we were last here, had the container ready to be moved, opened and inspected and moved. We had requested that the plaintiff have his agent at the port come to the port so we could have it opened. The court indicated that he agreed with it was a good idea to have it inspected when it was opened. However, we've had no contact whatsoever from Mr. Owenu or his agent. It's still sitting there.
Your Honor, I also have had no contact other than this. The agent in Nigeria has said that he is not allowed to enter the area of the port where that container will be opened, not even as a guest of the owner of the container. And therefore, he doesn't see that he's able to do that. Other than that, I don't have an update on this.
As far as it's not accurate as far as we know, Your Honor.
He's there in Lagos. I'm here.
I have the same problem.
Yeah. So I haven't heard whether the agents did or did not communicate.
They have not, according to my client.
I think the gentleman who's representing the plaintiff in that regard thought perhaps that he'd given us a final answer when he said, I can't go there. And therefore their desire that I go there is not possible for me. And maybe he thought that was the end of it. But that's where we sit at the moment. Your Honor, you've been very, very patient with us. I can understand that may be coming to an end. But we are actually still working on this. We just can't seem to communicate effectively with Nigeria.
So short of having an agent there to inspect the property, what hinders this matter from going forward? What hinders the container from being opened? What other issues are there in that regard?
Well, the issues is that given the track record in this case, Your Honor, we would be much more comfortable, and I think the court would be more comfortable if plaintiff's own agent were there when the container were open and the condition of the vehicle could be looked at least in terms of what's there and what's not there, and how it was shipped. Court may recall this started with, or may or not recall that this started with an allegation that we had stolen the vehicle and somehow sold it, and it's been sitting in, unfortunately, it's been sitting in the dock on Tin Can Island for since it was received there.
I was not counsel at that time, Your Honor, but I think what we're trying to deal with today is getting the thing opened, getting the car out, getting it to an inspection point. That doesn't seem workable on the plan that we approached last time. Mr. Onwenu is signaling me that he would like to address the matter, and perhaps he has something to say, Your Honor, that's enlightening, if Your Honor would permit it.
All I know.
Jones, you're muted. You have to unmute yourself. I'm sorry, Your Honor. Jones, can you unmute yourself?
Yes. Can you hear me now?
Yes.
Good morning to you, sir.
Morning, Your Honor. Everything that the defendants are telling you is not the way it's done in Nigeria. There are 4 cars in that container.
Right.
And we don't have any evidence of the names of the owners of that container. We have requested for that information for over 2 years. They never want to submit the names of the people who have their cars in that.
Jones, let's not go over grievances. Let's tell us what we need to do starting now to get this done.
Okay. They said that they will contact my agent. They never did contact my agent, number 1. Number 2, my agent is not allowed to go into the ports. Number 3, they have an agent that will bring the container out before it's opened. The customs doesn't allow the container to stay in the ports for 6 years. There's area that the containers are taken to. And this I do, I've been shipping for over 40 years. I never had a problem with that.
Okay, so you're saying they could bring the container out without opening it to a place where Chijoki could then go and be present.
Yeah, they call my agent will look at it. That's it.
Michael?
But they're saying that the container is in the ports. The container shouldn't be in the ports because they will be paying every day. It's like,
okay, let's not do this. Okay, they're not trying to case this morning. We're just trying to get the container opened and inspected.
yeah, they have to take it out of the ports.
It's delightful information to me to get some kind of insight into what the prospects may be of getting this matter moved along. So it seems, at least from Mr. Owen, who's 40 years of experience in shipping, he said that the challenge here is to get the container out of the holding area, and then the parties can do whatever they want to do as far as inspections are concerned. Mr. Elkins, let's get that container out of the port.
Your Honor, we don't own the container. We lease the container. So I'm not sure how much latitude we have to get it out of the port, because the longshoreman, the shipper there, I think, has an interest in the container. I can check on it. And just for the record, Your Honor, I've been involved in this case since day one. There's never been a request, formal or informal, for anything to do with the other owners of the other vehicles, which I'm not sure are relevant here anyway.
I didn't think they were relevant either, but you know, who knew?
Different place with this case now. You're at a pivotal point where everybody knows where the vehicles are, and it's a matter of moving containers and getting the vehicle inspected in an area where the inspector is allowed. I mean, the logistics, maybe Mr. Owen knew, given that this is where it is now, maybe he has something to say about those logistics, because obviously that's an important part of this. Mr. Owen?
Your Honor, he can move the container from the custom area to your house and offload and bring the container back. That's the way it's done. I can also get you a specialist in Detroit who can say the same thing to this court.
Your Honor, I did not say they could not be done. I said I'm not aware of how they do that there.
I do. I've been doing this for 40 years.
Okay,
I'm not arguing with Mr. Owen. I'm saying that I don't personally have the information. I could certainly check and report back, or see if we can't get this organized in some way.
It seems like you're going to need the geometry here, sir.
I'm sorry, I couldn't hear you, Your Honor.
Mr. Coleman, it sounds like you got to have the geometry here. The straightest distance between 2 points, or the shortest distance between 2 points, the straight line, the geometric straight line.
yes, sir. Perhaps, Judge, you could just bring us back sometime in the middle of next week I will be on this night and day, I promise you, and I will get to the bottom of this.
Yeah, I can bring you back. This case has a star on my my document on all of my computer case management documents and what have you. So yeah, I'll bring it back next Thursday. And I think everybody knows what you got to work on here, you know. And I think they're working with Mr. Owenu and his vast knowledge in terms of how to get the container out of that area. I heard Mr. Elkins say that the owner of the container has an interest in this, so obviously that's going to come up somewhere. I don't know how that works. It says that the owner of the container has some interest that his container is being used, it's storing something. There may be fees associated with that. But all that being said, I think that Mr. Owenu can provide critical information in terms of how the item can be shipped out of the port or the customs area, and then we go from there. So next Thursday, I'll set this over for 10 o'clock next Thursday. Let's take a look at it. I need some progress to be made on it. I mean, I would, you know, of course, courts operates through written orders. It would be like an issue of order to people in Nigeria, but in Lagos. But the last time I checked, I don't have that.
That may be a little outside the bailiwick, Your Honor.
Yeah. Active futility, you know. So I don't think I'll try that approach, and nor do I have that level of hubris neither. So get worked on the parts that the court can't reach, and the parts that pertain to this case, and the court can address those issues. So next Thursday at 10 o'clock a.m., I'll set the matter over, and we'll revisit the matter at that time.
Thank you so much, Your Honor.
Thank you. Good day to all.
Thank you.
All right, we're on the record regarding Chuike versus 6th Precinct Department. The matter is before set on for a motion hearing on today's date. The plaintiff has filed his motion for summary disposition in this matter. In lieu, I believe, of any answer having been filed, I see a motion for summary disposition. All right. The defendant, the plaintiff has indicated his presence here. I call for the city of Detroit, your appearance at this time for the 6th Precinct, I guess it is.
Good morning, Your Honor. Christopher Michaels, P83156, on behalf of the city of Detroit, named as the 6th Precinct in this case. And I apologize for being late. I actually had not received a copy of the notice, but their clerk was grateful enough. I'm grateful enough that she gave me a call. So I'm appearing on behalf of the city.
Thank you. Thank you, Counsel. So you filed a motion for summary disposition. Mr. Chuike indicated to me earlier when I called the case that he filed a petition for entry of default against the 6th Precinct. I indicated to Mr. Chuike that his default application is contained in the court's file dated December the 19th of 2022. I also pointed out that I have the motion for summary disposition that's dated December the 9th. The gentleman thought that the motion was filed after his application for default, but the records show that the motion was filed and received by this court December the 9th. The application for default was received by this court on December the 19th. And so I indicated, as I will now, that the request for entry of default will be granted where there is an answer that is allowed by the court in the form, or that is allowed by the court rules, a response that is allowed by the court rules, and that is the response in the form of a motion for summary disposition. All right, now, Mr. Chuike indicated that he had not received, I believe he indicated he had not received a copy of the motion for summary disposition. Is that correct, sir? Mr. Chouike, did you tell me that you have not received a copy of the motion, sir?
I called downtown. I called downtown and they told me they didn't respond to you guys. They responded to me. I was sent a letter. Was the reason why I called downtown. So when I called downtown, they told me the letter you guys did, they didn't respond to you guys. So I came downtown to file a motion. So what I was told was they only responded to me. They didn't respond to the court. So that was why I came downtown to file a motion.
Yeah, well, there's certainly nothing wrong with you filing the motion. The responses in the court's file dated December the 9th. So they're not in default. The city or the 6th precinct is not in default because the motion was filed before there was any application for default. All right.
But I was never given a hearing date for my
I'm sorry?
case. I was never given a hearing date for the claim that I filed. All I received was a dismissal. There was no hearing for me to to state my case or to show my evidence. I didn't have the chance to do that.
Yeah, this is a hearing date, but this is not a trial date because under the court rules, you may not be entitled to a hearing date if there is a basis for granting the motion for summary disposition. You only get a trial if there is a triable issue. And what the council is raising in the motion for summary disposition is that this is not an issue that can be tried before this court for the reasons set forth in the motion. Have you read the motion, sir?
Have I read the motion?
Yes.
No, I haven't read the motion.
All right, but you have received the motion.
Yes. No, when I received it, I read it, but I can't remember everything that was said. I have to read it again. Like I said, after I received it, I called downtown and they told me they didn't respond to you guys. So, I just left it at that and came downtown to file, for default. So.
Okay, we're past that part. And if you repeat that 16 times, we're already past that part. So if that's what you want to talk about, then you won't be able to get to the next part of this case about because we're past that part. You got that?
Correct.
All right. Now, the motion, I'm going to hear from the other side as to what they believe should be their basis for this case being dismissed. And then I'll come back and hear from you as to why you believe or don't believe that should be the case. Mr. Michaels, you may at this time, sir, on your motion.
Thank you, Your Honor. I believe it's well laid out in the brief. I guess just to start, the 6th precinct department is not a distinct legal entity, but it is presumably it's against the city of Detroit law. The city of Detroit Police Department is what his claim is, at least deciphering from what the affidavit says. And as stated in the city's motion, they are entitled to governmental immunity under MCL 691.1401 because there are no facts alleged and there's no pleading an avoidance of governmental immunity. It appears he is disputing what appears from his affidavit to be some sort of police action, and there's no allegations in avoidance of governmental immunity. And so at this point, we would ask the court grant summary disposition under 2.116C7 and also C8.
All right, you've heard the nature of the motion that is filed here. Sir, any response that you wish to make at this time?
Well, Your Honor, I have a video, recordings, I have paperwork of the claims that I filed and what was done. And, all I need is a fair chance to state everything that has been done to me and everything they did, because everything they did to me was intentional and it was done repeatedly. So I was jailed twice for no reason. The last time I was jailed, I was kept there 3 days and was let out with no paperwork. The first time I was jailed for a ticket that there was no reason. And those tickets were dismissed and they kept holding my vehicle for no good cause. So I kept getting harassed from them. So all this has put me in a situation where I'm living in my vehicle because they noticed that the police doesn't respond to me. They shot me with a gun. The police didn't do anything. The neighbors hit me with a bottle, punched me, assaulted me. They didn't do anything. So it's like everything that I complain about was nobody cared about my complaint, but everything that was done to me, I have to come to file a claim to the department and show my evidence of everything that was done to me because my car was parked in the driveway. They pulled up into that driveway for no good cause, no reason. They towed my vehicle to make me walk home. So they just doing things to me for no just cause. So I started recording them because they're doing things repeatedly. So I want to have the chance to show the court everything that has been done to me.
All right, thank you. Thank you, sir. Mr. Michaels?
Just to briefly reply, the rules regarding governmental immunity, the government immunity is broad and the exceptions are narrowly drawn. And from what Mr. Chukwukwe is stating, it appears that he has some sort of dispute regarding police actions, which is clearly a governmental function. And so the city and the police department are entitled to governmental immunity unless he can bring some sort of allegation that would be an avoidance of that. But from what he's stating here, it appears just a dispute with how he feels he's treated with the police, which is not a tort cognizable under Michigan law.
I don't have a dispute. But that's why I kept the recording to show what was done to me so the judge could see that. Because if I just say it, you think I have a dispute, I don't have no issue with the police department. They're the one harassing me. I went and filed the harassment. They didn't stop. I filed the harassment on them when they started. They didn't stop. They continued. So that's why when I spoke to Conaway, he told me to keep a recording of what they do to me. So I started recording. So with the recording that I kept is what I'm trying to show. So it's not a dispute, it's what they did. It's what I'm showing. So I have paperwork and recordings of everything that I'm saying. So when the judge can see what I'm saying, you will know I don't have an issue with the law. I call them when something's done to me, they don't show up. When somebody called them and said I did something that I didn't do, they come and take me to jail. That's unfair. So you took me to jail. You didn't charge me with nothing. You just let me out. Do you expect me to just let that be? And you towed my vehicle. And you did all those things for no cause.
Thank you, sir. Are you getting the last word, if any, Mr. Michaels?
No, I think the motion lays it out quite well, the legal grounds. So I think I'll just rely on that brief, Your Honor.
All right, thank you. The court has read the motion in this matter and has listened to the arguments thereon. Really, the issues that are raised by the plaintiff in this matter, they may be recognizable under some legal claim or legal theory, but the case that he's presented to the court is not the manner in which he can bring this matter before the court. He assumes the 6th precinct, which is not a legal entity. And for the first reason is that he's suing an entity that cannot even be sued at law. He could, in fact, sue the city, but the kind of activities that he's described, the city of Detroit is immune from that. Even if they may have done something that was improper, incorrect, the city under state law is immune, cannot be sued for the kinds of actions that the plaintiff is raising in this complaint. That's because of governmental immunity. That's because the law makes the city immune to things like that. And you would have to consult with a lawyer because there may very well be a way that you can go after claims that you may have. They typically involve suing some individuals and not some entity. But you can't sue the city of Detroit for claims of this nature involving various governmental functions. And you certainly cannot sue the precinct because the precinct is not even an entity. It is a operation within the city of Detroit. And that operation is immune. The city is immune. But of course, police officers and city employees get sued all the time concerning various matters. But under this scenario, in this case, there is nobody being sued. There is a precinct being sued. You can't do that. Legally, you can't do that. The law does not recognize such a lawsuit. It does not recognize you being able to sue what action may have occurred by some individuals, and you sue the city or sue the precinct because of something that some individuals may have done. And that's why the law, those entities are immune. You can't sue them. So for that reason, the motion for summary disposition is granted. By granting that, that dismisses this case. It does not say that Mr. Chioke, and I'm sorry if I pronounced it wrong, does not have a claim that he could bring under some other scenario. Can't bring it in this type of case. Can't sue the 6th precinct. Can't sue the city of Detroit. So this case is dismissed on the grounds of governmental immunity and on the grounds that the party that is sued as defendant in this matter is not a legal entity. This case is dismissed as court. All right.
Well, Your Honor, my evidence was not shown to what I'm filing for is what they did to me, not what the individuals did to me. That's why I wanted to show the video so you can see what they did to me.
Well, and you may be able to show that video if you sue in the correct manner. The issue here is that the type of lawsuit that you brought, you'd never be able to present evidence because you're suing an operation that does not exist as a legal entity. I don't expect you to understand it because you're not a lawyer, but if you're going to sue, you got to follow the rules. And the rules does not allow you to bring this action in the manner that you desire to bring it. It doesn't allow you to do that. And because it does not allow you to do that, it doesn't allow me to hear your evidence. I can't, that's like if you're coming here today and you're suing, let me give you kind of an example that hopefully illustrates the point. Well, I see that you're not interested in my example, so I won't give you an example. So do whatever you feel that you need to do. You can appeal me. You can appeal me on this decision. You have the right to do that. And so I made my decision. I'll send you an order so that you can go ahead and appeal me. Good day to you, sir. Thank you, counsel. Good day to you.
You said the court will be sending the order out? You said?
Yes, sir.
Okay, thank you, Your Honor.
We still have Mr. Cox in the breakout room.
Let's see. Yeah, he and Mr. Itonio are still there.
Okay, all right.
And I have a Miss Hurst that's in the hallway. Bring her in.
Yeah, I see that.
Well, she can, in fact, we can bring her in.
Bring her in.
Yep.
Okay.
All right, this is case number 22-194-228. This is Angela Hurst versus Midtown Auto.
I don't want you to trip the phone. Yeah, just slow down.
matter is before the court, set on for a hearing with regard to a complaint that was started I should indicate, in August 2022. And the allegations in that complaint are against Earl Julian Simmons and Midtown Auto. The complaint in this matter alleges that Earl Julian Simmons, along with his girlfriends, identity theft and stole my driver's license 3 times, GoFundMe in my name at Gardner White, and other areas of fraud and theft. And the plaintiff is seeking $25,000. All right, do I have Angela Hurst here?
Yes, sir.
All right, come to the podium right there, ma'am. Well, you can stand where you are, and good morning to you, ma'am. All right. And do I have Motown or Earl Julian Simmons, either of those persons here at this time?
No, I met down all
All right, what's your name?
Albert.
I think you know that you can't just come to court and say your name is Albert. What is your name?
Oh, Albert Hart. Hart, Albert Hart.
H-A-R-T?
H-A-R-B as in boy.
Okay, all right, thank you, Mr. Hart. All right.
Excuse me, Judge, I'm not suing Midtown Auto.
Well, it seems that in the lawsuit that you filed, you listed Midtown Auto.
That's his address. That's Earl Julian's address.
All right, so you don't have any interest or any claim against Midtown Auto, correct?
No, I don't.
All right. All right, well, any issues that have Midtown listed as a part of this lawsuit be dismissed at this time. I give you 1 second, Madam Reporter, what did you say?
I was just wondering if she could put the camera on the plaintiff and defendant. Yeah, that's all.
She's making that adjustment. Just one moment.
Okay.
And I do have an answer from Earl Julian regarding this matter. So, sir, if you're with Midtown, and now it's been indicated on the record that Ms. Hurst does not have any claim against Midtown. And so the case is dismissed against Midtown. So you're free to go.
Thank you.
So Ms. Hurst, I need you to come I need you to stand up at this time, ma'am. Raise your right hand to be sworn. You do solemnly swear or affirm that the testimony that you're about to give is the truth, so help you God.
Yes, sir.
All right. So, ma'am, I got a written response from Mr. Julian, but he has not appeared. But the claim that you brought here seems to be all over the place. Is this someone that you dated before?
Yes,
Okay. How long ago did the dating relationship end?
last year.
Last year, 2022?
Yes.
All right, so you tell me about your complaint in this matter, and what evidence do you have regarding what someone may have done to you?
When I have Earl Julian.
Okay, I'm gonna need you're behind the plexiglass, so I'm gonna need you to just pull your mask down a little bit. So tell me what Mr. Simmons did then.
When I have Earl Julian 7 years, he's gaslight me all the time, and he used to steal my money and steal my property and come to my house and paperwork that I have that I had court case against the post office. He was still that and bring it back a couple of days later while we knowing, and then he would take other paperwork that I needed. I had court cases against certain people like Kelly Wilder, and he was dating her, and I didn't know that he was still that. And he would hide it behind his pants and doorknob, and he would give it to her. She would come to my house, take that, and he was taking all my paperwork, and I couldn't never get to court. And then for my taxes, he would take my taxes, and when he would take my taxes, he would get my taxes, my stimulus check, and then he still stimulus check. And then someone.
She keep her voice up, Judge.
Gotta keep your voice up because my court reporter is trying to take down everything. You said he was steal your stimulus check and those kind of things,
He was
Deborah?
stimulus checks from me, and he was stealing my money from me, he was going to my bank account, that he could do, and he knew people that, and he could.
Okay.
And he worked with the Arabs, and the Arabs, and him all.
Okay, my clerk can't hear you. You said that he would steal your money out of your bank account, and he will work with the Arabs, get your money some kind of way, correct?
Yes.
1 second. All right,
Sorry.
okay, go ahead, you continue, ma'am.
And then, one day I had to go to the hospital at Providence Hospital. And Providence Hospital was not really a hospital, like the fourth floor. We would be in there by 3:30, the staff would leave. And he had a girlfriend by Victoria Jenkins, and she stole the form out there. And the form she stole would be her, the Earl Simmons, permission to be my overseer and my caregiver. When that happened, he went to DHS and became my caregiver. He was that pandemic was giving out $190. He still that. He was going on my food card, different places, using my food stamps. And I didn't find out until a long time ago.
Right with you, Mr. Cox, Mr. Tony.
Thank you.
Kept going. And be aware of it till like this year. And I was able to get BDB into it. I was able to get the coin side for the bank to help me with it. And I was able to get the three transit unions to help me with it. Finally get a lot of the media Medicaid fraud on my insurance and then to my insurance. And then he did insurance claim on the car, he was car crash. Try to get car crash money for it. He did a lot of stuff and then undermined to a thing. Until someone yelled out that he's identity theft to do. And that's how looking into all of being identity theft by this man.
So how long were the two of you dating, ma'am?
I say about 3 years. For 3 years, we had a lot of time to think about money.
All right, so have you gone to the police with all of this?
Police with it, and the police, Detective Benny went to my checking account and found the discrepancy in my checking account. Found money in there. I know if you go to the police report, you get the police report. Detective Benny found out, JP Morgan found out and called me up and asked me to go on my account. Detective Benny and Detective Benny, Detective Brown, if I'm mistaken, his girlfriend was doing sex crimes. But she had a camera in my apartment, take pictures of us in the room, and those pictures. She downloaded 200 pictures to me, and I didn't get them all, but I got half of them. She had cameras in my apartment. She sold the phone company, it was going to T-Mobile, getting phones, AT&T, getting phones, using my driver's license. She used my driver's license, he used his bag, and his regular, identity, to the store, to purchase phone.
Okay, so have you got all that stuff cleared up, ma'am?
I got it all, finally got it all cleared up until, I decided to upgrade my insurance. We bought back the old insurance cards, and then I got to see him ask that my, insurance be breached again.
All right, I'll be, just one moment, ma'am, I'll be right back. All right, we're back on the record here, regarding the, suffix 2963. This is Farm Bureau Insurance versus, Corey Anthony Itoni. And the matter set for review on today's date. I know the parties went to a breakout room, to talk about this a bit. Mr. Cox, if you could update me at this time, and then I'll hear from Mr. Itoni as well.
Yeah, so Judge, I had sent the defendant, our office had copies of the breakdown of the repairs that were done to the vehicle, and several points were raised about challenges to amounts that he thought he would be responsible for based on how the action occurred. And we spent about 15 minutes diving into all of that. And then somewhere in there, he mentioned the fact that he believed that his car was fully insured on the date of loss, which I basically said that's sort of like burying the lead on this case, because the first allegation we make is that his car was uninsured. And if it was insured, we would be dismissing the action. So we sort of took a turn off the beaten, what we were discussing, to the idea of whether there's actually active coverage on this vehicle. The police report indicates that there was a policy, or there was a glove box certificate. My client's notes indicate they tried to follow up with that and never could find a policy. And so I think what needs to happen is we need to cross this element of our claim off the list, as it were. And so in addition to me going back to my client, it became more difficult to settle the case, Judge, when the possibility remains it may not stand up if he can prove active coverage. And so I'm not sure why we kind of glossed over that last month, but it appears that we did, or wasn't raised. And I think we need a little additional time for Mr. Tony to go to his carrier and see if he can demonstrate there was valid active coverage on the date of loss.
Yeah, I mean, that's a biggie there. If you had coverage, you believe you had coverage, right, Tony?
Yes, on the day of the accident, my car was for sure insured. I just bought it 10 days prior.
Yeah. Well, that's, we definitely got.
So I'm pretty sure it was insured.
I'm sorry?
Judge,
Yeah, I'm pretty sure it was insured.
I gave him my email address. I have his. I gave him my direct dial telephone number. I have his. And I encouraged him that if he wants me to communicate with the carrier, I can, but he needs to get the ball rolling as it pertains to identification of the carrier and the policy numbers and all that, and see if he can get a deck page and a document showing that coverage was active, because that's typically how we go about this when we are trying to confirm it. And I think we've got a strategy to try to get that accomplished.
All right, so if I bring it back in about 30 days, that should be enough time, you think?
Well, that's what I expected would happen. I told Mr. Tony that's where we think it's headed. So I think so, but it's a lot of it's going to fall on his shoulders to see what he can do about communicating with his carrier and getting the documentation. So the short answer is I think yes.
All right, so what I'm going to do then is I will, in fact, I'll bring it back on the 23rd, February 23rd. And we'll go ahead and set it for 10 o'clock. And by that time, we should know that crucial question regarding insurance, and that may very well resolve the case. If not, then the court will address other ways that we can move forward with this. So I'm looking at the 23rd of February, 2/23, 23, and that's at 10 o'clock a.m.
Very good.
Thank you.
Thank you. We'll see you at that
Thank
time.
you, Your Honor. All right. Thank you, Judge. Have a good day.
Thank you.
Okay, we're back on the record in 4228, Angela Hurst versus the defendant in this matter, Mr. Earl Julian Simmons. So you told me a lot of things, ma'am. What proof do you have? What documents or anything that you have showing that any actions occurred?
I brought in, it's kind of ripped out, the paper from the hospital. He came to be my caregiver, and I brought in the tax paper, and his girlfriend went to Woodward. He stole the tax paper from there and filed a claim, and DTV told me to go there and get a tax paper so I could get home heating credit. And I went to go get home heating credit. DTV said I couldn't get it because Kelly Wilder filed for me. Is I was offended.
Because who filed for you?
Kelly Wilder. Is I was offended, so I couldn't get home heating credit. And then last year she paid $219 back to DTV. So I got my money back.
Okay,
And then
Did you get your money back, you said?
Yeah, DTE got the money back for the home use credit for me. And then, she also went to, do taxes and filed taxes against me again. And got my taxes for, $1,400. And took that and put it on the, property taxes. She did it again. And I went down there and I filed taxes for $1080 for, my taxes being stolen. And I sent my original statement, and they gave me a home use credit of $1,800 for, what is it,
So they gave you your money back.
they gave me my money back. I got $349. Then she did it again, and did taxes. I didn't get the tax back this year when I filed taxes. I have it on me and file that the taxes didn't come to me, so I took my taxes. So about that.
What's her name?
Her name is Kelly Wilder, and she's a sex offender, and she's a, for driver's license or something. And I had took it and I wrote, big letters on it, stuck in my window, so everybody can see who she is.
All right,
And then I got 2 letters from the IRS for my stimulus checks, $1,400 being taken away. And then I got those back. And then when I did my insurance, I was gonna upgrade my insurance. He used my old insurance card again. It blocked me from getting my insurance. I just closed that out and get back to my other insurance. It was safe if I got a CMS saying that my insurance was breached. So I had to go back to the 3 credit bureaus and let them know my insurance was breached.
now which insurance are you talking about? Health insurance?
Health insurance.
All right. You've been able to get, when you needed health care, though, you've been able to go to the hospital and get health care, correct?
Right, it was racking up bill. He was racking up bill, he racked up $4,000.
And so what has happened to those bills?
Medicaid is investigating.
So if they find out that somebody committed fraud or something, they're going to waive those charges and you won't have to pay that, correct?
Right, I don't have to pay that. He has to pay.
Are they finished with your investigation yet?
Yes,
And so they said he has to pay, correct?
right.
Okay, can you give my clerk a copy of your stimulus check stuff that you were talking about?
Made a statement with this one now.
I hear you now.
I said I made a statement with this one now.
That's okay. Now, are those documents gonna show me that Mr. Wilder, Mr. Simmons stole your money?
About this, this space, money was missing.
That the money was missing?
Yeah.
Do you have anything to show me that Mr. Wilder stole the money?
Oh, this is a statement from the police department in City of Detroit that I'm clear of everything. And everything I'm saying is clear for me.
Okay, so they gave you a clearance that you didn't do anything wrong, correct? Now, have they filed any charges against anybody, like Mr. Simmons?
Yes,
Is he under, is he charged with a crime right now?
I believe so. She said my name is clear of everything, whoever that you picked out. He said it gives me investigating now.
Okay,
So I'm clear, this is a clear statement from me.
okay, let me take a look at that. My clerk's gonna receive that from you. Let me take a look at that, that you have. All right, let the record reflect that I received a certified record copy. It says a review of records indicate that there is no open violation registered to the above individual, and that is in regards to Ms. Angela.
I don't know, it depends on how many copies you get, Ms. Sparks, because you might have to go to the second floor and make your own copy.
That's okay, we won't need. And these documents basically show that the person is not a criminal defendant. The paperwork you sent me, fingerprinting, other items along those lines. Okay, they show that you're not in any criminal situation. Okay. Anything else you wanted to tell me?
This is PMS letter that I got from my insurance being hacked.
All right. And they corrected that they're not charging you anything for it, right?
No, they haven't charged me nothing for it. They want me to go through the credit bill, and let them know that my insurance was hacked.
Okay.
And I bought the new pack that he used.
All right.
Old insurance card.
All right, man. So if he did something like that, you've identified him to the agencies, and they're going to go after him for any of that activity, correct?
Right.
Okay. What else did you want to tell me, ma'am?
Taxes. I gotta find that. Taxes.
Well, you already indicated to me that with regards to the taxes that
Right.
that they refunded your money and gave you your credit ultimately, right?
And she did in 1,800 on my house.
All right, and you're gonna follow the same procedure you followed previously to get that reimbursed to you, correct?
Right, and try to do that.
All right. All right, ma'am. Anything else?
This is about stress. And, he ordered 7 bottles of lithium. I did that. 7 bottles of lithium, 4 bottles of clonazepam. Dr. papers for me.
Okay, those are psychotropic drugs, correct, ma'am?
Right.
So you have a mental health condition?
Yeah, I have a health condition. I don't take 7 bottles of lithium. I take 1 bottle.
Okay. Okay. So this, I mean, but he would have been ordering that stuff at the time that he was your guardian or something, correct?
Right, couldn't be my guardian.
Okay, anything else, ma'am?
That's about it. The 1,400 a piece.
Huh?
And I called the controller for the bank. That's these birds right here. Tracks out that is to it. That's these that is here.
Okay, so did any of them, did any of the banks or anybody provide any identifying information as to who may have taken any money out of your account?
No, not the point. He was going through it and he was trying to find out who's doing it.
And if there's someone that improperly took money from you, the bank would give you your money back. Is that correct?
Yes.
All right, ma'am. Anything else? I think you told me everything, but if there's something else coming.
I think you pretty much got a good idea of this one.
All right, thank you very much, ma'am. Well, yeah, listen, the court has listened to the evidence offered in this matter, and from that evidence, I can't find where you have a cause of action against the persons who you are alleging claims against today. First of all, the only person that you've alleged a claim against is Mr. Simmons, And you've also brought up a Miss Wilder today. Any activity that Miss Wilder may have engaged in, and moreover, you pointed out to me that when you complained and raised the issue that the taxes were refunded to you, that she may have engaged in some fraudulent activities involving taxes and with DTE. But when you brought it to their attention that that they resolved the issue, and if it's come up again, you're resolving. But if that had not been the case, you don't have a claim against Miss Wilder because you didn't sue her. You sued Mr. Julian. You didn't sue. I should say
Yeah,
Mr. Simmons.
because there was
Don't stop in that. Stop. It's my turn to talk. Okay. You didn't sue her in the claim. I know that a part of your allegation is that they were in a dating relationship and that he may have been dating Miss Wilder. But still, if you believe that Miss Wilder stole something from you, you would have to sue Miss Wilder for that. But more importantly, even if you sued her for that, your testimony provides that there is a remedy already in place, and that is that the money was refunded to you, that it was given back to you, that you didn't suffer any loss as a result of that because of the taxing entity refunded your homestead tax property credit, so on and so forth. So that one's not really even before me because you're not suing Ms. Wilder, you're suing Mr. Simmons. In addition to that, you pointed out to me situations where Mr. Wilder may have taken advantage of you in the context of a dating relationship, and that you took those items to law enforcement, you took those items to the bank, and you took those items to the health insurance entity. You've indicated that the health insurance entity has either corrected what was done or will correct it, and that you will not be charged for anything that Mr. Simmons did that was improper as it relates to the insurance. You also stated that you filed claims with the bank that money was taken from you, and that if it is established that money was taken from you improperly, that the bank is going to refund you for the money that was taken from you. Of course, they're not going to refund money. I don't believe that in the situation where if you were in a dating relationship and gave the person access to your account, they are not likely to refund your money under those circumstances. But where someone took advantage of you and they find that that's the case, the bank will refund money to you. A part of the problem here, it seems to me, is that at some point, while you appear to be under disability, at some point, it seems to me that Mr. Simmons became your guardian or a person that was in charge of your affairs. And if that person was in charge of your affairs, they would have the right to make use of your assets in order to assist you. But if they do that improperly, then you would take that matter to the police and they would bring the proper action, and you would go to the banking entities and they would take the proper actions to correct that. The final thing that you brought before the court is the issue of the stimulus checks, and you indicated that those were stolen from you, but you were not able to provide me with any evidence as to Mr. Simmons having stole those. You told me that you believe that he stole them, but you don't have any evidence establishing that that is in fact the case. Moreover, you did tell me that you filed complaints with the appropriate agencies regarding your stimulus check, and that it is their duty to investigate that. And if they paid your money out to somebody improperly, then they would be required to refund your money to you because they paid it to someone improperly. If, however, Mr. Simmons was your guardian, and well, if he wasn't, ma'am, don't interrupt me. If he was your guardian, then they may find that because he was your guardian, that he would have the right to collect the stimulus money. But if he was not your guardian, then he would have, I don't see a basis upon which he would have the right to take your stimulus money. And if he did, the right thing for you to do is to file that with the appropriate agency so that they can investigate it and make a determination in that regard. And if they make that determination, then they're required to pay the money to you because they sent it to the wrong person. That's not a matter for this court to resolve. That's a matter for the Department of Treasury, the Federal Department of Treasury to resolve. If they sent your check to the wrong person, or if someone defrauded you, then that agency is required to pay you the money that they paid out fraudulently to someone else. So that's the mechanism where you pursue that. That's not a matter that's before this court. I have gone over your complaint and the issues that you have raised regarding your complaint. While the defendant has responded to the complaint and did not appear, the court would normally enter a default under those kinds of circumstances. But I don't see a basis for relief in this matter. The issues of harassment and so on and so forth, those are a part of your experience in the dating relationship that should have been brought and could be brought as a domestic abuse, domestic violence in the criminal context. But those are not actions that wherein you can collect monetary damages before this court in the context of a claim brought before the 36th District Court. I don't see where you have a cause of action for relief regarding the claims that you have brought before the court against Mr. Simmons. Your relief is, as you have already indicated, your relief is to go before the various agencies that money may have been taken from you and to file a claim so that they can adjust those claims and make a determination on whether or not something was taken from you, and they have to refund that to you or have to give you credit for something that they are charging you for if someone else fraudulently created those charges. But you don't have a case before this court. You don't have proof to establish anything by a preponderance of the evidence that would give rise to the court entering a monetary judgment in this case. And for that reason, this case will be dismissed. You just don't have enough evidence to establish that anybody is entitled to monetary damages in this case. The court can award equity. The court doesn't have the authority to order that someone stay away from you or to order that someone engage in some kind of behavior or stop doing something. The only thing that this court could do is to award money. And I don't see a basis for awarding money. Much of what you claimed have already been credited back to you. And the issue with the stimulus, you have to continue to pursue that with the Department of Treasury until they get that straight. That's not an issue that's before this court. So this case is dismissed, ma'am. Good day to you.
Okay.